Welcome to another episode of Life After Corporate, my friend. And if you're new to our show, hey, welcome. This is where you meet the best experts that will help your startup grow. We cover things from the financial side, from sales, from marketing. And today we're going to talk about legal issues and trademarks. So our guest today is Lauren Bercuson, and we are grateful to have her here because it's getting harder and harder to find a brand that you can protect. So welcome to Life After Corporate, Lauren.
Thank you, Deb. It is so nice to be here today. It's such an honor to chat with you. So I'm thrilled to talk trademarks with you.
Yeah, so I've enjoyed all the time that I've spent with you, and thank you for coming into our Reliable Revenue community and talking about trademarks. It's getting crowded out there. So I heard a statistic recently that 20,000 new businesses are launched every single day. And, it's so hard in those early days because you're kind of still figuring out what is your market, who's your ideal client, what's your value proposition. And sometimes in those early days, we come up with names that don't really stick. So my first question for you is, when in the business launch and growth journey should people be looking at trademarks, especially if they haven't yet gone through their market research phase or their branding phase? When is the right time to start thinking about trademarking their brand and their company assets?
So that's a great question. And I think that the right time is really when you have a name that feels right. When you have that name that sticks, which usually happens before you start, launching, because once you start creating your website or creating your products or whatever it may be, you already have a name that you're using, right? So once you've done the research, once you have that name that feels good, that you think you're pretty confident you want to move forward with, then is the time to start. You want to search and make sure the mark is clear for you to use before you launch. There's nothing worse than launching an amazing new business, however small it is, and then getting hit with a cease and desist letter because you're unintentionally infringing on somebody else's brand. So really, I think before you launch is always ideal, especially if you're a product-based business, because if you have to rebrand and, you're out your product packaging, your boxes, all of your, hard materials, we're looking at tens of thousands of dollars, if not a lot more. So always, when you have a name that you're pretty sure is where you're going to move forward, that's how you want to go.
And what are some of the mistakes that you see people make? Because I can pick out a couple, like, oh, I have it. I already own the URL. I bought the URL, so I'm protected.
Yep.
Why is a URL insufficient to protect your brand?
There's no policing, bottom line. Anyone can buy a URL, right? And if I am StoryLock Legal, that doesn't prevent somebody from going out and buying the StoryLock Legal, right? Anyone can do that. So there's no mechanism, no board to make sure that no one's infringing on somebody else's mark when you just go and purchase a domain URL. Same goes for registering your business entity. All of my clients, maybe not all of them, 90% of my clients, like, well, I think the mark is clear because I've already registered, right? I've already incorporated. That doesn't mean anything, unfortunately. When you are incorporating your business, there isn't a body that's checking to make sure that the name that you're incorporating under isn't somebody else's business. And one of the reasons for that is likely because a lot of people don't actually operate under their entity names. So for example, my business entity is LB Legal Creative, because when I was starting, I was like, I'm also a writer. So I was like, I want to do some writing and I want to do some law. I'm just going to call it this. And then if I know that I really want to move forward with my law firm, I'll create my own brand name. So that's not my customer. That's not my forward facing entity. It's just a business name. So those business names, they're not monitored. If you have a trademark with the Patent and Trademark Office, the USPTO, the examining attorneys, almost act as like the police force, right? They're like your first line of defense, because if you have a registered mark, anybody who comes after you with the same or a confusingly similar mark, they're not going to be allowed to register. So That's kind of why, people think, which makes sense, right? We all would think, oh, well, my URL is available, or I registered my domain name, my entity, but that really truthfully doesn't mean anything, which is a hard pill to swallow.
It is. It always is. And, I think it's getting harder and harder to get a unique name these days. And so first of all, if you want to search your trademark, you go to uspto.gov. It is the test database. And why is it not even sufficient in that step in searching the test database? So I know I've been in a position before where I did a Google search, I searched the test database, I went to my attorney and said, no, you don't need to do a comprehensive search. I've already done a search. And lo and behold, we found someone who had the same name and then filed at the same time I filed, but they had prior use. So let's break that down of why doing your own search isn't sufficient.
So, perfect example. Would you ever go to an ophthalmologist if you had a problem with your toes?
No.
Right? So, because an ophthalmologist is an expert in your eyes. Trademark lawyers are experts in trademark law. We know all the nuances. We know, what is confusingly similar. We know what that means. We know what we're looking for. So when someone is looking at a mark, right, they don't understand the doctrine of, what it means to be a phonetically equivalent mark. They don't understand how the goods and services and what is actually registered in connection with that mark or applied for. People don't understand what that means and how related the goods are. People don't know about the doctrine of foreign equivalence. So as an example, let's say that I am a cookie shop and my mark is Bluebird, right? And I spell it the way you would think it was spelled, BLUEBIRD. Well, let's say someone else comes along and wants to open Bluebird Cookie Shop, BLUBYRD. They're going to say, oh, well, there's nothing else. There's a Bluebird, but that doesn't matter because I spell it different and I have the words cookie shop at the end of my name. Well, guess what? If I tell you I got my cookies from Bluebird Cookie Shop and somebody else tells you, oh, these cookies are from Bluebird Cookie Shop, you're not going to know whether it's Bluebird spelled traditionally or Bluebird spelled BLUBYRD, right? That is exactly what the PTO is trying to prevent. They do not want customer confusion. So basically when a client goes to a trademark attorney to do a comprehensive search, we're looking at not just identical matches. We're looking at phonetic equivalence, so all different variations in the spelling. We're looking at the mark as one word or two words. We're looking at these other terms that might be added. We're even looking at foreign equivalence. So let's say your cookie store is called Red House Cookies, okay? And then I come along and I want to file Casa Roja for my cookie shop, right? And I think, oh, there's nothing confusing. My mark's in Spanish. Like, I'm so clever. Well, guess what? The PTO is going to get your mark and they're going to flag you and they're going to refuse you because there's already a Red House cookie store. And they look at Red House and Casa Roja as being exactly the same, likely to confuse the customers. So there's a lot of little nuances like that, no knock to anybody, but if you're not trained in trademark law, you're likely not going to pick up on. And that's where you start treading into, a little bit treacherous territory. So
what if Casa Roja was actually a consulting firm and Red House was a cookie shop? Could that be registered?
Yes. And that is a great situation. So look at Dove chocolate and Dove soap, right? Those are different owners, which a lot of people don't realize. It's not the same company. Now, because a customer is not likely to confuse chocolate and soap, and they're not likely to encounter chocolate and soap on the same aisle of a store, the powers that be have determined that they're not likely to be confused, right? So it is unlikely that Red House cookies would be confused with either Red House or Casa Roja consulting company because the goods and services are so wholly different that customers aren't likely to see those marks in the same place at the same time.
Yeah. And so what is involved in a comprehensive trademark search? So if I were to come to and engage you, and I'm still like figuring out branding ideas, like, so that's the hardest part, is even finding out what mark do you want to use. And we've incorporated, so our company name, our corporation is filed under the Great Do-Over. Our trademark and our company name DBA is Life After Corporate. We've trademarked that. We have the Life After Corporate podcast. Where do you advise people to go if they have a company name? Is it a brand extension and an endorsed brand identity like Life After Corporate Launch Lab? I mean, could I even register Life After Corporate Launch Lab if Launch Lab was already registered to someone else?
That's a great question. If Launch Lab is already taken by somebody else, then you would have a hard time registering that in connection with your goods and services. Now, interestingly, words like Launch Lab, if it is truly kind of like a lab where people are getting help learning to launch their brands, could arguably be descriptive. Or there could be so many different, launch laboratory or launch accelerator. Like there could be so many different uses that are present in the PTO that it could be what's called a crowded field, meaning that so many people are using those terms for similar services that the customer is accustomed to recognize that they have to distinguish between each mark, right? They have to look at other distinctive portions of the mark because those words are so common. So I actually love the Great Do-Over because it really doesn't give you any hint of what the goods or services might be. And that is actually scary to a lot of business owners, but those kinds of marks make the absolute best trademarks because they're the most distinctive. And the more you move away from descriptive marks and move into marks that are suggestive, like the Great Do-Over, or arbitrary, like Apple for computer, or fanciful, like Lululemon for, athletic wear, then you're getting into really protectable marks and really distinctive names. And that's always where we want to be. People will say to me, but if I say something like the Great Do-Over, then people aren't going to know what my goods and services are. But yes, they will, because that's what great branding and messaging does. And once you connect your mark to your services with a great story, you're going to hook your customers and they're never going to forget your name. When there are, the launch lab or launch accelerator or, launching project and all of these things with the same names, people get confused, right? There's too many to distinguish between. So those stories with a great mark, that's going to really set you apart.
And then what's the process? So I've gone through the branding exercise. I've got a mark that tells a great story, whether it's descriptive or what was the other word you use?
Distinctive?
Distinctive or descriptive. What is the process that one goes through when engaging you? And what do you do once you get a client? What's the next step?
So the next step, once someone engages me for my Trust Your Trademark package, which is really my most popular package, first we'll do that comprehensive search. So we're going to look at your mark in connection with your proposed goods and services in the PTO. So we're going to look at applications and registrations, and then we're going to look at common law marks, meaning marks that are in use but haven't actually been registered yet. And the reason that we look at those marks is because even if an owner hasn't taken steps to actually apply for their trademark registration, they would still have superior rights if they have been using the mark, longer than you. And so let's say the PTO looked clear, and so you apply and you get your mark. That other third party that's been using the mark for longer could actually go to the PTO and try to have your registration canceled on the basis that they're the prior owner. So that's what we never want to happen. So we analyze the comprehensive search. We look at all the data. We decide whether we think it's, low risk, moderate risk, high risk, and moving forward. And if we think the mark is clear, we'll file the application. all of our conferencing, emailing, that's all included in the package. We get your application on file, and then we walk it through, every step of the way, with the end goal obviously being registration. So typically when you work with an attorney, the initial work is done fairly quickly, depending on if the mark is clear or if you need to make some changes. But then once you get it on file with the PTO, you're waiting like anywhere from 8 to 10 months for the PTO to even begin to review it. So the purpose, though, of that comprehensive search is to allow you to move forward with confidence, knowing that your mark looks good and looks fair.
Yeah. And with all of these new businesses coming up and everyone becoming much more aware of the importance of trademarks, trademarks are harder and harder to get. So how do you advise clients who are at these early stages and saying, how do I choose a trademarkable brand? How do I choose a name that the likelihood of registration is high? What are some of those considerations? I know you're not a branding consultant. I know you partner with one, but how do we go about that?
Honestly, the best thing to do is be as out of the box as you can. The closer you get to that arbitrary and fanciful mark, the better off you're going to be. If you make up a word, chances are you're going to be just fine, right? Because no one else is going to have that word that you made up. So here's a perfect example for you. I think you know that in my past life, in my former life, I was a children's book reviewer, and I have a blog, and my blog is called Happily Ever Elephants. And my name came from my son, who's now 12. When he was a toddler, he would read a book and he would end it and say, "And we lived happily ever elephants." No idea how that happened. So I used it as the name of my blog. Well, in a world of blogs about children's books, which have become, Bookstagram on Instagram has become very, very popular, and it's a very saturated market. There's I love books, mommy loves books, kids books rock, these books rock. Well, guess what? Happily Ever Elephants, the moment you hear that story and the moment, you hear that it's in connection with children's books, then everyone remembers, the Elephants blog or the Happily Ever Elephants blog, right? No one can distinguish between all of the other blog names that all sound the same. So the more unique you are, and sometimes it's even like the less your name has to do with your goods and services, the more you're going to stand out. Because everyone, for SEO purposes, people think, but I have to tell, I have to give an indication of what we're doing. There are plenty of other ways to get your website noticed through SEO than having a descriptive trademark. Does that make sense?
Yeah, it does make sense. And so interesting, as someone who's come from corporate, our marks were always descriptive. That was, the ethos that came down from our CEO is our branding was very descriptive. It was the company name for, whatever client or industry we're looking to attract. So you could tell what it was. So you needed distinctive marks are better these days. And Happily Ever Elephant also kind of is almost half and half because it implies a book, the end of a story, happily ever, and then it kind of fools you at the end, which I really love that approach. So now you've got your trademark. Now, suppose your URL isn't available. Does it make sense? Because many people register a lot of URLs because for the intent of selling them because they're popular. So Life After Corporate, after we decided to change over the business name to something more descriptive, that URL was already taken. So we had to pay, I think, $2,500 or something like that for the URL. Is that worth doing?
That's really a business decision, and SEO people, brand people have their own ideas about that. I mean, it depends. If you have a registered trademark and someone is sitting on your URL and won't give it up unless you pay them thousands and thousands of dollars, there could be a cyber squatting claim there. So, that's one thing to consider. But, some people will say, rather than, let's go back to my cookie house, right? Like Red House cookies, you could do Get Red House or Shop Red House or Red House cookies, the back, like you could add on to get
Mhm.
or put a dot in somewhere. There are things that you can do if the URL isn't available. But if you have a registration and your URL is not available, you are in a better position to negotiate for the one that you want.
And if someone else is using your mark, so for instance, if someone has an Instagram feed that's called Life After Corporate, is that an infringement of a trademark?
So that's a very interesting question. And if they are not making money, if they're not using the mark in commerce and it's just an Instagram feed, then it likely is not going to be an infringement. The same way that if your only use is that you have an Instagram feed with 1 million followers and you're not necessarily monetizing it, you're not doing anything with it, you're just posting pictures of your life, that you might not have a trademark claim there. So it really depends. There are so many nuances on what you're doing. Are you advertising? Are you influencing? How are you, like, there's a lot of stuff to look at. So it really, depends. And some of it is determined on a case by case basis, but you have to be using the mark in interstate commerce to identify the source of a business. So that's kind of the test. That's
What
what.
about things like podcasts? Because we've all heard of shows that are named exactly the same and they have two different hosts. Now, the first time we got our trademark, we trademarked the podcast name
Mhm.
because I wanted that to be a unique asset.
Absolutely.
It's, the podcast itself doesn't make money. It's not used for sponsorship dollars, but we do get clients who are listeners of the podcast. So I guess you could consider that. So do you recommend that people trademark their podcasts?
Absolutely. Especially now, because podcasts are hot. People are using them very often as a way to make money. I just had one client that got a cease and desist letter for their new podcast name because somebody else had a similar podcast with a similar name. So I didn't clear her mark. I told her, they came to me after this. So then I was like, you're infringing. You got to change the name. But, podcasts are a really hot area and easily protectable. And yet you do not want to start a podcast that is too confusingly similar to another name out there because they can come after you.
Yeah. What are some of the cases where you may get a cease and desist or there may be a trademark infringement, but it is worth fighting?
It really, it's so nuanced, right? Based on the differences in the marks and the differences in the goods and services. So, one example is someone gets a cease and desist letter after filing an application in the PTO by a big company, right? And their services aren't the same. One offers a tech product, one offers consulting services, but they're both in the business field. Very different. One
Mm.
element of the mark is the same. That could be a situation you want to fight. Now, it's hard when it's a big company, right? That has a lot more money. So maybe there's a way that if the smaller company is willing to rebrand, the big company will give them, some money to do that if they want them to stop using the marks. There's lots of different situations, but the more closely the goods and services are and the names are, the harder it's going to be to go forward with a mark. But there are certainly cases, and it happens all the time, where, there's pretty significant distinctions and you could each carve out your own space. And in those cases, it's very worthwhile to fight for something you've built up because customers aren't likely to be confused.
Yeah. What was the most interesting or the most difficult trademark case that you've ever handled?
Ugh, that
Dish out the stories, Lauren.
in the day, I mean, like 20 years ago, when I was a baby lawyer, I was in like a 2.5 week, 3 week trial, and it was two men who were fighting with each other. They had been in business together. The mark was like a conglomeration of their initials, if I remember, something like that. I can't even remember all the details. It's like I'm dating myself. And they just hated each other. And so they could not figure out how to go about ownership and what happens to this trademark and who had it first. There were so many like small, nuanced gray areas. I honestly can't even remember what happened with the trial. I'm pretty sure our client won, but it was a whole new world to me because it was my first real, big case. These are big construction guys in New York and Florida. And I just remember the fighting being so bad and how much would have been prevented had they started off with a strong agreement, partnership agreement. There was just so much involved, but it was awful. I just think that feelings can really make things really bad. And that's why you just always want to start smart and protect yourself from the get-go. Other things that you hear are people assigning their businesses away without really realizing what they're doing, assigning away their names. There's so many things that can go wrong.
Trademarks have value. Like when you sell your company, the valuation changes based on your trademarks. How do trademarks affect company evaluations on a sale?
So they're a tremendous value add to your company. The bigger and stronger your trademark portfolio, the more valuable that your business is. And that's exactly what we mean by saying that trademarks are business assets. Trademarks can be licensed so you can monetize them. I mean, they're such a value add. They're money-making machines, truly. And people don't realize it, that, a little investment up front can come back to you huge down, when you're looking to sell or looking to exit, because they really just add such value to your business.
Yeah.
Especially if you're looking to sell, if you're looking for investors, like they want to know that this brand is secure.
Yeah, so that is really key. If you're looking for funding, you have to own the mark that you're looking to get investors to back.
Exactly.
Yeah. What are is there anything else that we haven't touched on that you think it's really important for newish entrepreneurs to understand about trademarks?
I think that is a great question. Well, first off, don't ever use the R in the circle, the registration symbol, if you don't have a registered trademark. You can get yourself in a lot of trouble there, because that's actually illegal. You can be fined. But aside from that, I think that being proactive rather than reactive is the smallest and easiest thing to do in your business. And it is shocking how much it is ignored and overlooked, that concept. Spending a little bit of money up front. And I know that when, people are starting businesses, money is often tight. People are often bootstrapping, but starting smart and having a lawyer help you with your name, which is the foundation of your business, everything you're building on, making sure that that piece of the building block isn't going to fall, right? It's going to keep you steady and is going to be a strong foundation is everything. Because if you spend that initial money up front, and again, $2,500, give or take, it's what most of us charge for our full packages of clearing the mark and applying for the mark, can save you tens of thousands, if not hundreds of thousands of dollars down the road. So it is always important to just start smart, make sure that your mark is clear. Because the last thing you want to do when you start a new business is to get hit with a cease and desist letter because you're infringing on somebody else's name. Even if it's unintentional, it doesn't always matter. So
yeah. And even if you're not a product entrepreneur and you don't have packaging, if you're a service entrepreneur, you have digital assets.
Exactly.
And that brand is all over the place.
Exactly.
So this has been really enlightening. So Lauren, I'm sure that your phone's going to be ringing after this airs and everyone needs to get their trademarks registered. How do people get in touch with you and what is the best way?
Absolutely. Well, you could find me on my website, which is StoryLockLegal.com. You can find I hang out mostly on LinkedIn. So at Lauren Bercuson. I also have a great educational free guide. That's a 6 days to getting trademark smart. It's just an email series, but it gives you such a good overview of the basics with no legal jargon. So if you want to get a little bit of background before you jump on a free consult with me, that's a great place to start. And I'll give you that link. So it'll be in the show notes, and that's where you can find me.
Sounds great. Thank you so much, Lauren, for sharing your expertise. I think it was very enlightening to sort of peel back the layers of trademarks. And thank you so much. And I look forward to seeing you at our next opportunity to get together. This is great.
Absolutely. It was so great to be here, Deb. Thank you so much.
Thank you, Lauren.